Hello, this is Professor Keith Ross from the John Jay College of Criminal Justice. This is going to be part 2 of the Introduction to Law and Justice chapter. We are going to start at slide number 16. So when we're talking about the actual criminal justice system, on this PowerPoint it's split into 4. In most textbooks, it's split into 3. Doesn't really matter to me how you view it. I actually view it as 3 as well, but for purposes of this lecture, we'll deal with the 4 parts. So the first part of the criminal justice system, and this part usually begins whatever the criminal justice system is going to deal with, and that would be the police. And the police really serve sort of 3 functions. They are law enforcement, and if you switch those words around, you know what police do. If police are in the law enforcement business, well, what do? Well, they enforce laws. So they enforce laws that the legislature writes. Service to the public. When we're thinking about police, especially uniform police, usually the common thinking is that all police do is that they effect arrests and that they issue summonses. At least on the patrol level of policing, this is really far from the truth. More often than not, a police officer's day, if they are uniform patrol, is basically listening to the radio and answering calls on that radio. So therein is the public service. The last one is order maintenance, or maintaining the order. You can see this at any parade that ever takes place. I know right now in the time of COVID, there are no parades, but think back to any parade. I'm sure everybody here, if you've never attended a parade, you've at least watched the Thanksgiving Day parade once. Well, if you've watched the Thanksgiving Day parade, on the streets of New York City, all the floats go by and all the marching bands go by. Then there are police, there are metal barriers, and then there are the spectators, the civilians that are watching this parade. Why are the police there? The police there, they do maybe enforce the laws, but especially like on Thanksgiving, there's really not much law to enforce. They're not answering jobs, so they're not doing public service, but what they're doing is making sure that order is maintained in the crowd, that everyone gets to see, no one does anything silly. So that's sort of what we're talking about here. Slide number 17. Now, slide number 17, I actually sort of think about with slide 18. So for me, in my head, the criminal justice system is broken into 3 parts. And your textbook, Introduction to Criminal Justice textbooks also break it down this way. There are police, there are the courts, and then there is the correctional system. So if we're thinking about the courts, after the police have done whatever it is they do, let's say they effect an arrest, what they're going to do is they're going to bring it to whom? The prosecutor. What do prosecutors do? Well, prosecutors prosecute cases, or they try cases. What that means is that they are a representative of the state, and what they're looking to do is to represent the state's interests. If someone has broken the law, or if someone has if there is probable cause that someone has broken the law, what they're looking to do is they're looking to prosecute this case and bring, justice to society. So in New York City, each borough has one elected district attorney. So the district attorney, the main job is run by election. So at least in New York City, there are 5 boroughs, so there are at least 5 district attorneys, one in the Bronx, one in Manhattan, Queens, Brooklyn, and Staten Island. There is also a 6th district attorney, and that district attorney is assigned to the Special Narcotics Division. Basically, what they're doing is they're trying drug cases, and usually we're not talking small amounts. We're probably talking more trafficking and sale type cases. What prosecutors do is they decide how and when, or even whether, to prosecute criminal cases. Now, that sort of seems weird when you think about it. Well, the police effected an arrest, so why does the prosecutor get to decide? And the real answer is, let's think about legal burdens of proof. When we're talking about the police, what is the legal burden of proof necessary for a police officer to effect an arrest? Well, that would be probable cause, that an offense has been committed and that the person about to be arrested is the one that probably did it. Do the police 100% know? They do not. What do prosecutors do? Well, what prosecutors do is that they have to bring a case to a criminal trial, and they have to prove a person is guilty beyond a reasonable doubt. So this is 100% that they have to show that the person that is accused of this offense is guilty. Because in our criminal justice system, in the American criminal justice system, and probably a lot of the criminal justice systems worldwide, there is a presumption of innocence. That is why a person can never, ever be found innocent at trial. The presumption is that they are innocent already. They can only be found guilty or not guilty. And there is a big difference between being innocent of something, meaning that you definitely didn't do it, or being not guilty. That just means that there was not enough evidence to support a guilty verdict. And prosecutors are sort of that link between what the police do and what the courts do. So now I'm on slide 18. What do courts do? Big college word. They adjudicate criminal cases. Now, if you look at that word adjudicate, you can sort of see a word. To me, the word that I see in that is the word judge. So what do criminal trials do? Well, they render verdicts. They judge whether a person is guilty or not guilty. Either a judge or a jury will issue this verdict of guilty or not guilty. Obviously, if we're talking about jury trials and we're talking about criminal trials, this is going to be 12 people, 12 of the accused peers, citizens. However, as a defendant, I have the choice of whether I want to be tried by a jury of 12 of my peers that are impartial, or I can choose to be adjudicated by a judge. If I choose a judge trial, that's called a bench trial or a trial by the bench because the judge sits on a bench. Just as a little bit of a side, statistically speaking, more people are found not guilty at bench trials than they are at jury trials. The judge resolves questions of law, while the jury resolves question of facts. What the jury is looking to do is to see whether something has happened or not. What the judge will do is rule on whether, let's say, a statement is admissible, an assertion that one of the lawyers, either the prosecution or the defense attorney, is asserting will be allowed in the record or, quote unquote, stricken from the record. A little messed up here. Sorry about that. Number 19, the correctional system. Now, the first bullet point, I don't really like the way it's written. The care and custody of convicted offenders. Doesn't necessarily have to be convicted offenders. A person could be accused and could not raise bail. Right now, there is bail reform laws and procedures going throughout the United States of America. But if a person was offered bail and they could not come up with that bail money, well, then they would be detained in either a jail or a prison. More likely than not, it would be a jail. The goals of correction and criminal sentencing are, I'm going to give you four for my corrections class. When we start talking about this, we're actually going to discuss 5. But for purposes of this sort of introduction to criminal justice, really that there's 4 that we need to sort of focus in on quickly. Retribution, that's sort of an eye for an eye. Let the punishment fit the crime. Deterrence. Well, if someone knows that if they commit an act, they could go to jail for it, possibly they might decide to not commit that act for fear of going to jail. So then we have deterred crime. Incapacitation. What this means is that if someone is incarcerated, if someone is behind bars, while they are behind bars, they cannot commit another offense to society because they're incarcerated. Doesn't mean that they can't commit offenses within the jail system. It just means that they can't commit offenses outside of it. And then the last one, and in the last 10 years, especially in New York City and a lot of major urban centers, is this idea of rehabilitation. One of the goals of the criminal justice system is that upon exiting the criminal justice system, we want to make people better than when they entered the criminal justice system. Now, this is going to apply for defendants or convicted individuals as well as victims. Not saying that the criminal justice system does a great job of this. I'm just saying that that is one of the goals. And if someone is incarcerated, a lot of people want to think, well, you know what? Well, they're locked up. Let's throw away the key. However, there are people that work in these jails, and if that person has done their time, they've served their sentence, well, now we want them to be productive members of society. So here's an idea of rehabilitation. Maybe someone enters the criminal justice system and they are now a convicted felon, does not even matter what they committed. Let's say they entered the criminal justice system without a high school diploma. Well, while they are incarcerated, they can get their high school diploma. Let's say you have a high school diploma and you're going to be incarcerated for 8 years for whatever it is you committed. You can actually get your bachelor's degree. You can get advanced degrees, master's degrees. There have been cases where people have been incarcerated and have received doctorates, or they become lawyers, and that actually does happen more than you would think. Slide number 20, the court system. There are really two types of courts when we're talking about the criminal side or the criminal justice system. There are trial courts and there are appellate courts. What do trial courts do? Well, they adjudicate cases, meaning that at a trial court, at the conclusion of it, we render a verdict, whether a person is guilty or not guilty. Appellate courts, sort of a misunderstood concept, but if you look at the word appellate, you can see the word appeal in it. So an appellate court listens to appeals. What they do is they review the decisions of the trial court. Now, this might sound like semantics, but it's actually not. When you appeal a case, you're not appealing the verdict. You're not appealing the guilty verdict. What you're appealing is the process by which the jury arrived at this guilty verdict. Maybe there was an unreasonable search and seizure. Maybe evidence was not obtained legally or procedurally correct. All things like this. And this is what an appellate court would examine. Jurisdiction, a court's authority to hear a particular case. If I'm driving in Delaware and I'm speeding and I'm doing 95 miles per hour and I get pulled over by, let's say, a Delaware state trooper, and I'm issued a summons for speeding in the state of Delaware, well, I can't answer that out in New York State. Why? Because New York State does not have jurisdiction over the vehicle and traffic laws of Delaware. So something like that. You can't go, let's say I get arrested for a criminal offense. I can't go to a New York City traffic court and have my case heard because they don't have jurisdiction. So usually we're talking either the type of case that it is, family court, traffic court, or actual locations. Now we're going to talk about trial courts, and I'm going to focus this in on New York City. Now, I want you to be careful because I'm going to tell you this. On a quiz and on your final examination, I'm going to mess with words. So, the first trial court, or the lowest trial court in New York City, is called New York City Criminal Court. There is no such thing called New York State Criminal Court. So if you see New York State Criminal Court, you know already that you can cross that out because there is no such thing. New York City Criminal Court, there is one in each borough. So in New York City, we have 5 criminal courts, again, in the 5 boroughs: Bronx, Queens, Brooklyn, Manhattan, and Staten Island. Now, the second bullet point, please pay attention to. Arraignments. What is an arraignment? Well, an arraignment is the Sixth Amendment right that I have to know the charges being leveled against me in court, being brought by the prosecutor. So an arraignment for any type of an arrest, whether I'm arrested for a violation, a misdemeanor, and or a felony. The very first time that I see a judge, I will see that judge in New York City Criminal Court. In the last slide, we're going to talk a little bit more about this. But just for now, put a star next to that second bullet point. All initial arraignments will take place in New York City Criminal Court, regardless of the offense, whether it is urinating in public, whether it is murder. The very first time I see a judge, and the very first time that I hear the charges leveled against me, because that's what I'm accused of, will take place in a New York City criminal court. Trials for misdemeanors and or violations will take place in New York City criminal court. So it might very well be, let's say I'm accused of a misdemeanor, let's say in New York City, assault 3, which is a misdemeanor. I will be arraigned in New York City criminal court. If I enter a plea of not guilty and I decide to not take whatever plea bargain the district attorney or the prosecutor offers me, and I want to go to trial, well, that trial will also take place in New York City criminal court. Next one, slide number 23, New York State Supreme Court. Be careful with this too, because I will put New York City Supreme Court. No such thing. The other thing I want you to keep in mind is that New York State Supreme Court is a very different arena. It's a very different court than what the United States Supreme Court is. They serve two very different functions. So New York State Supreme Court hears both criminal cases and civil cases. I don't really care about civil cases because for purposes of what we are going to be learning this semester, we're focusing in on the criminal justice system, and civil cases are wrongs against individuals, not against societies. I believe, if I remember correctly, if memory serves, that when we're talking about civil courts, we're looking for some sort of compensation. I think it's $25,001 or more. It's something to that effect. But again, it's not a testable concept for me, and it's not anything we're ever really going to discuss moving forward. I just wanted you to hear it. Here's criminal cases. Now, think back to the last slide. In New York City Criminal Court, all initial arraignments take place there, and what else takes place there? Well, trials for misdemeanors and trials for violations. So what would be left? Well, felony trials take place in New York State Supreme Court. So if I'm accused of a felony and we go to trial and the charges still are some type of felony, that trial will take place in New York State Supreme Court. Grand juries take place in New York State Supreme Court. I'm going to talk about this again on that last slide. Do not make the mistake that what a grand jury does and what a trial jury judge is the same thing. They are completely two different things, and they have very different purviews as to what they examine. A trial jury renders a verdict. What a grand jury sort of does is look at the evidence to see if it is enough to go to trial. So obviously, grand juries take place before a trial. New York State Family Court. If I decided to not teach anything about New York State Family Court, you could probably figure out that what New York State Family Court deals with are issues with families. Basically, issues either via bloodline, via matrimonial lines, or via intimacy, whatever intimacy means. And that would be on a judge to rule whether someone has an intimate relationship. You can remember what the family court does by the acronym PJ-CAPS. They hear cases related to paternity, juveniles, child custody, adoptions, PINS petitions, and spousal support. So then we sort of have it all sort of covered. Either blood, usually with the juveniles and stuff, the matrimonial stuff, spousal and child support, and or intimate relations. Slide number 25. I want you to look at this. On that bottom box where it says New York City Criminal Court, New York State Supreme Court, and New York State Family Court. Right next to that, what I'd like you to write are trial courts. All three of these are trial courts. So trials take place in New York City Criminal Court, New York State Supreme Court, and New York State Family Court. For purposes of what we'll be talking about, More often than not, we'll probably either be talking criminal court or Supreme Court, not too much family, although I think in my policing section, we might discuss family and juveniles a little bit more. So let's say I'm at New York State Supreme Court, I'm accused of a felony, I'm found guilty, and my lawyer and I have a conference and we decide to appeal the case because we want to appeal the process by which they rendered that verdict. Well, the next highest court in New York State is the New York State Appellate Division. So that's sort of a middle court. So they'll hear my appeal. I'm appealing something in the process of how the trial jury arrived at a verdict of guilty. The appellate court can do a couple of things. They can hear my appeal and concur with me and then sort of dismiss the case. They can agree with the trial court's ruling or they can kick it back down. More often than not, for purposes of what we need to talk about, because we're not really focusing on the legal system, we're really focusing more on either policing or corrections. Let's just say they concur with the trial court. But I'm adamant that there was something wrong with the process. Maybe the police didn't conduct a legal search, whatever it is. And I don't concur with the New York State Appellate Division's finding of concurring with the trial court. You know, it's starting to get a little weird. Well, there's the next highest court, and this is the highest court in New York State. This would be the New York State Court of Appeals. Now, they can hear the case, and they do exactly what the other appellate court does. They look at the case, they look at what our or the defense team's assertion is, what was the problem with how the jury arrived, and they can either concur with the defense or they can uphold the trial jury's finding of guilty and the appellate division's concurrence as well. There's one last court that I could possibly appeal to, and that would be the United States Supreme Court. That is the law of the land. It is the highest court in the United States. There is not a higher court in the United States than the United States Supreme Court. So we're not talking Interpol or anything like that. What the United States Supreme Court does is a little bit different than the other appellate courts, because what they do is that they don't look at the case, but what they look at are the constitutional issues possibly brought up by that case. I think in the chapter 1, we were talking about the 14th Amendment, and I brought up the same-sex marriage statute. And the United States Supreme Court ruled on the constitutionality of the states barring same-sex couples from getting married. And they stated that it was unconstitutional. So that's sort of what they do. Last slide number 26. There's only one slide, but there's a whole lot of information here, a whole lot of testable information. I'm definitely testing it on this quiz, and I'm definitely going to test on our final examination. So we're talking sort of a 12-step criminal justice process. Step number 1 is investigation. Now, this is that very first police-citizen encounter. So maybe a citizen goes, officer, police officer is in uniform, no reason to doubt their credibility, no reason to think that they're impersonating. Police officer goes up to the person requesting their help. What can I do for you? Officer, someone stole my cell phone. Did you see who did it? And let's say this person says, yeah, he did it. And there's a guy standing there holding a cell phone. Now, a lot of things could happen. Now, the officer could ask more questions. But at this stage of a game, we have a victim. And at this point in time, do we have any reason to doubt the credibility and the validity of the victim's statements? The answer to that is no, which it is. Well, now what does the police officer have? Well, the police officer has probable cause, because a reasonable person, and this is how the law is written, a reasonable person looking at the facts and circumstances of this case at the time the police officer encounters it what would they think? The person who's being pointed out probably did it. Again, do we 100% know? You probably did. They probably did it. We do not. Does a police officer need to 100% know? They do not. As long as they have probable cause and they effect this arrest in good faith, it is a good arrest so far. So let's say the police officer asks a couple of questions. Are you sure that's him? And this person says, absolutely. He ripped it out of my hand 3 minutes ago. Cool. Police officer, all they have to do is go up to the person that's being accused, and all they have to say is, all right, do me a favor, turn around, face the wall, place your hands behind your back. Now, here's an interesting thing that a lot of people think needs to happen, but does not need to happen. Most people, and it's probably because we're informed by what we see on TV and the movies. Let's say I'm the police officer and I'm like, all right, buddy, do me a favor, turn around, face the wall, place your hands behind your back. I now handcuff that person. Most people feel or think that I need to read this person their Miranda rights, their Miranda warnings. You have the right to remain silent. Anything you say can and will be used against you in a court of law. Do you understand? You have the right to an attorney. If you cannot afford one, one will be appointed to you at no cost by the system. Do you understand? A police officer does not have to issue Miranda warnings right now. Miranda warnings only ever get triggered, and this is an easy way to remember it, custody plus interrogation equals Miranda. Meaning, is this person in custody? Yes, he is, because he's in handcuffs. And what does custody mean? That's real easy. Custody means that a person is not free to leave. So if they are in custody, they're not free to leave. However, this person's in handcuffs, and I ask him, what's your name? What's your date of birth? What's your address? What's your phone number? What's your email address? Do you have a Facebook? Do you have an Instagram? What's the screen name? Am I asking anything regarding criminality? The answer to that question is no, and it is no. Am I interrogating? Well, let's look at the definition of what interrogation is. Interrogation basically is asking a person about personal criminality, something against their legal or penal interests. Now, if I were to put this person in handcuffs and say, hey, buddy, why'd you steal the cell phone? And he gives me this whole story. Well, if I ask, why did you steal that cell phone? Now what am I doing? Well, now I'm interrogating. Before I ask that question, what I should have done is then read Miranda. But if I'm only asking pedigree stuff, name, address, stuff like that, I never have to read Miranda. Miranda only ever gets triggered when it's custody plus interrogation. So now this person is in handcuffs. What do we do now? Well, I'm going to bring him back to the station house because I'm going to process this arrest. One of the rules of policing is if it's not on paper, it did not happen. So I have to memorialize this on paper. So I'm going to fill out whatever the requisite paperwork is in the jurisdiction of New York City. At the very least, I'm going to be filling out what's called an online booking sheet, otherwise known as an arrest report. There might be other paperwork, maybe lost stolen property forms, things of that nature, witness statements, does not matter. But I do have to memorialize it there. There's something also very important at the station house that a police officer must do. And what a police officer must do is fingerprint. Because I could bring somebody back to a station house and they can tell me whatever name they want to tell me. And there is no legal right for me to ask for ID. However, I can inventory this and I would have the correct information if this person has their ID on them. But that's another lecture that we'll discuss, especially for both my policing and my criminal investigation classes. Corrections, we're not going to really talk too much about this, but we'll get into some of this ideas of searches. So station house processing. I ask this person their name. They give me a fake name. Your fingerprints never lie. And, some of you might be really super, super smart and you look this up online and you'll find something called a chimera, CHIMERA, where a person has the same exact fingerprints as another person. And truth be told, it is mathematically possible for this to happen. I think the chances are like 1 in 40 or 1 in 50 billion that this could possibly happen. However, it is mathematically improbable that this would happen. And just so we're on this topic, what about identical twins? Well, identical twins have identical DNA samples. However, they do not have identical fingerprints. They have very similar fingerprints, but there are some marked differences. And we'll sort of discuss that later on. So I've done all my paperwork. I've fingerprinted my prisoner. Now let's talk about what this person did. Well, he ripped a cell phone out of a person's hand. So right now, what we have a larceny. We define a larceny as the removal of property without permission or authority to do so. This is going to technically be called a grand larceny. Why was this a grand larceny? Well, it has nothing to do with the dollar amount of the cell phone. The cell phone could be a 15-year-old cell phone that's worth $20, or it could be the newest iPhone iteration. Does not matter whether it's worth $1,200 or whether it's worth $100. The reason why this is a grand larceny is because it was taken from the person. So since it was taken from the person, no force was used other than taking the phone, so it's not a robbery, and it's going to be a grand larceny. If it was just, let's say, sitting on a bench, then it would be a petty larceny with the proviso that the phone wasn't worth $1,001 or more. So we're going to charge this person with grand larceny. We're probably also going to charge them with criminal possession of stolen property, because if they stole something and they had it in their possession, well, now we have stolen property as well. So let's just say we're going with these two charges. Grand larceny in New York State is a felony. So now what happens? Well, now what we're going to do is we're going to transport this person that's been accused of this offense. We're going to transport them to, at least in New York City, called central booking. What central booking really is, there are two major things that happen in at least New York City central booking. The official mugshot is taken of the person that's accused of this offense. And I think the more important thing is that custody of this person transfers from the police to the courts system. Now, for any of you that might have experience with central booking, you're going to notice that there's police officers and there are corrections officers. Although corrections officers are watching these people that have been, at least in the starting throes of their incarceration, they are not in the jail system yet. Right now, they are incarcerated by the courts. So I just want to make sure we get that. So I've dropped my prisoner off at central booking. He or she is going to do whatever they're going to do, which probably is going to be that they're going to wait for their case to be brought up to New York City Criminal Court and speak to an attorney, probably one that was appointed to them. Well, I, as the police officer, am I done for the day? Well, probably not, because I've submitted paperwork, and this is going to go to the courts at the very least for an arraignment. Well, someone's going to want to know about this. And who is that person going to be? Well, that's going to be the district attorney, the person that's going to have to decide whether they prosecute this case or not. So, number 5, we're going to prepare a complaint with the ADA, the assistant district attorney. Now, you know what? I sort of skipped over this. I said that there were 6 district attorneys in New York City, 5 for each borough and 1 appointed to the Office of Special Narcotics. More often than not, police officers are never going to deal with the elected district attorney. They are going to deal with people that work underneath that person. These are assistant district attorneys, and they're the ones that are actually doing the majority of the work. They're the ones that are prosecuting this case, assessing evidence, assessing charges to make sure that whatever it is, they can, at the very least, hopefully have a successful prosecution. So the ADA is going to be asking me questions, and they're basically going to ask NIATWE questions. Yes, this is another one of my acronyms. NIATWE, when, where, what, how, who, and why. I might not be able to answer all of them, but I could probably answer when this happened, where this happened, what happened, who did it happen to, who did it, who else might have seen it, how did it happen, and maybe I do know the why. If I can find out the answer to the why, and usually that's not a patrol officer's job, that's going to be more a detective or investigator's job. What we're figuring out when we're figuring out the why is we're figuring out either, it could be either called, and they mean the same thing, either the motive or the modus operandi. So now I've prepared my complaint with the ADA. Let's say the ADA decides, you know what, Officer Ross, you did a good job. You did a good job affecting this arrest. You did a good job writing it up. I'm going to stick with the grand larceny charges. So right now we're talking a felony, not a major felony, but a felony, grand larceny. Well, now what happens? Well, now the first thing that's going to happen to the defendant who was in central booking, he's been waiting to go to arraignment. So central booking is connected to New York City Criminal Court. What's going to happen is the district attorney is going to come out. The officer probably will not. The defendant and his or her attorney, the defense attorney, they're going to stand in front of the judge, and then the judge is going to read the charges. This is called arraignment. Why do arraignments take place? Because I have a Sixth Amendment right to know the charges being leveled against me. So I must know. So let's say what happens is the charges are read to me. My two charges are grand larceny, criminal possession of stolen property. As directed by my defense attorney, we enter a plea of not guilty. Let's say the judge releases me on my own recognizance, what's called ROR, and appoints a date to at least start a hearing. So now we've just finished 6. Now let's think about this. What have I been accused of? I've been accused of a felony. Let's start thinking ahead. I already said this. Where will the trial take place? The trial's going to take place, if it does take place, in New York State Supreme Court. So, and where am I right now? I'm in New York City Criminal Court. Number 7, a preliminary hearing. Now, more often than not, they don't really happen too much in New York City. In other jurisdictions, a preliminary hearing might take place, and if it takes place, it doesn't really serve the purpose of a preliminary hearing in New York City. It serves more of the purpose of what number 10 or the pretrial hearings do. But what a preliminary hearing does is it examines the evidence and it examines the charges and sees if there is enough evidence, if there is enough probable cause to proceed to a grand jury. Couple of things that I want you to remember about preliminary hearings, not too much. One, they take place in New York City Criminal Court, and they are open to the public. That's the only thing I really want you to know. Let's say a preliminary hearing was convened. They examine the evidence, they examine the charges, and they say, yes, there is enough to proceed to a grand jury. So now we're at number 8, grand jury. Now, where are we physically? We've been 1 through 7, we've been in New York City Criminal Court, but I've been accused of a felony, and if this goes to trial, it'll take place in New York State Supreme Court. The grand jury also takes place in New York State Supreme Court, which means we have physically changed venues. We have changed courts. We've been to New York City Criminal Court, and now we're at New York State Supreme Court. Keep this in the back of your mind, because hopefully number 9 will make more sense. What takes place at a grand jury? The grand jury does sort of what the preliminary hearing or the petty jury does, which is examine the evidence and examine the charges and sees if there is enough evidence, if there is enough probable cause with the charges to proceed to trial. Some things to remember about grand juries, especially in New York State. 1, they are closed to the public. Preliminary hearings open, grand juries closed to the public. This is more often than not done to protect witnesses. Some numbers we have to remember. In order to convene a grand jury, in order to have one, I need a minimum of 16 people to a maximum of 23 people. I could have any number in between, but at minimum, I need 16 people, at maximum, 23 people. So I could have a 23-person grand jury, I could have a 16-person grand jury, I could have a 19-person grand jury, does not matter, but at least 16, at most 23. So the first number I want you to remember is 16 to 23. The second number I want you to remember is the number 12. And what the number 12 is I need 12 people out of that pool of 16 to 23 people to examine the evidence, to look at the charges and say, yes, there is enough evidence, there is enough probable cause with the charges to proceed to trial. If I can get those 12 people to say yes as a prosecutor, what I have is called either a true bill, or more likely than not, you've heard this term, an indictment. When a grand jury renders an indictment against the accused, they are not saying that the person has been found guilty. That's not what grand juries do. Grand juries do not determine guilt. What they determine is whether there is enough evidence to proceed to trial. So hopefully you got that. Now, let's think. I got arrested by the police. I was brought to New York City Criminal Court. I went to central booking if I am the accused, and then I was arraigned. I was told the charges. Where was I told the charges? New York City Criminal Court. Now, we've had a grand jury. Where'd the grand jury take place? Well, the grand jury took place in New York State Supreme Court. And that grand jury decided to indict me, meaning that they've decided that there is enough evidence to proceed to trial. Now, here's the question. Have I been told the charges in New York State Supreme Court? Well, not officially. So therefore, a rearraignment on indictment in New York State Supreme Court will take place. Meaning, I was told the charges in New York City Criminal Court, but my physical location has changed to New York State Supreme Court. So now I have to be read those charges again in New York State Supreme Court. Let's say they didn't even change. They could change. Maybe they decided to up it to robbery, third degree. Who cares? Does not even matter. As long as I'm being accused of a felony and the grand jury indicts me on a felony, that trial will take place in New York State Supreme Court. Therefore, I need to know the charges being leveled against me at New York State Supreme Court, because that's where my trial is going to be held. Now, number 10, the pretrial hearings. Now, I always ask this question just to trip people up. When do pretrial hearings take place? Do they take place before or after a trial? Obviously, they take place before trial. There's about 17 or 18 pretrial hearings that could take place in New York State. We're just going to look at 5 of them. Another term, you could either call them pretrial hearings, or they're also known as suppression hearings, meaning that the goal is to see whether the evidence or statements were obtained legally, because if they weren't obtained legally, they will be suppressed at trial, meaning they will not be brought up to trial. So number 10, we're talking about pretrial hearings. The first one, MAP hearings. MAP hearings are based on a case, MAP versus Ohio. And what MAP hearings do is that they examine physical evidence and how physical evidence was obtained. Was it obtained via a legal search and seizure? So really, the only thing I want you to associate with MAP hearings is that MAP hearings have to do with physical evidence. What are we talking about in the scenario that I brought up? The cell phone. Second pretrial hearing I want to talk about are called Huntley Hearings. What Huntley Hearings talk about are statements and admissions, and were they obtained legally? Let's go back to this scenario. Officer, someone stole my cell phone. Do you know who did it? Yeah, that guy did it. So now I effect this arrest. And the person says, I tell him, all right, buddy, do me a favor, turn around, face the wall, place your hands behind your back. And all of a sudden he issues this statement to me, officer, I killed my girlfriend. And I'm like, oh, really? Cool. Tell me about this. And he tells me about this story that they were arguing over the TV. He goes into the kitchen and stabs her in the neck. So now, not only have I charged him with grand larceny, well, now I'm probably going to charge him with murder, maybe manslaughter, although I think murder sounds more likely because there's an intent, a criminal intent here. If he had the knife on him, I would charge him with criminal possession of a weapon. Maybe later on we tack on that charge. Who cares? What a Huntley hearing is going to do is, since I've charged him with murder, why did I charge him with murder? Well, I charged him with murder because of the statements that he made. And they're going to examine, did I obtain those statements legally? So now let's take a look at it. Buddy, do me a favor, turn around, face the wall, place your hands behind your back. As of this moment right now, have I asked anything about criminality? The answer to this question is no. I have not asked anything regarding criminality. The only thing I did was to give a procedurally valid order to turn around, face the wall, place your hands behind your back. This person says to me, "Officer, I killed my girlfriend." What the courts are going to examine is, did I do anything to elicit that statement? "Officer, I killed my girlfriend." The answer to that question is no, because all I did was ask this person to turn around, face the wall, place your hands behind your back. So more likely than not, the Huntley hearing would not suppress that first statement. "Officer, I killed my girlfriend." But then what did I, as the police officer, say? I said, "Tell me about it." And then let's say he rattles off this whole story. I know I have a couple of past students, so you've actually heard me tell the story a little bit more in detail than I'm going to memorialize on video. But I ask him to tell me about this. Well, I, as a police officer, what am I asking him to tell me about? Well, I'm asking him to tell me about criminality. And then he tells me the story that he and his girlfriend have an argument over whatever's on TV, and he goes and stabs her. Well, now, if I asked him, tell me about it, what was wrong? Well, here's what was wrong. What am I actually doing to him, the defendant, right now? Well, I'm arresting him. So if I'm arresting him, he's in my custody. He's not free to leave. When I asked, tell me more about it, well, what was I actually asking him to tell me about? Well, I'm asking him to tell me about criminality. So then this becomes an interrogation. So custody plus interrogation equals that I should have read Miranda first. So the first statement, "Officer, I killed my girlfriend," would not be suppressed. All that other stuff about the fight over the TV and going to grab the butcher knife and stabbing her in the neck, that would be a suppressed statement. What I should have done is, as soon as he said, "Officer, I killed my girlfriend," what I should have done is said, "Listen, buddy, I want to hear all about it. I want you to tell me everything that you feel you need to tell me. But before you tell me anything, I have something I have to tell you. You have the right to remain silent. Anything you say can and will be used against you in a court of law. Do you understand?" And et cetera, et cetera. The next hearing, Wade Gilbert Stovell hearings. And what they do is they examine eyewitness identifications. Well, maybe in this scenario, what they're going to look at is, how did the officer pick this person from a crowd? Well, how did he? Because a victim pointed at this person. Let's say we changed it up and the victim comes up to the police officer and the police officer says, "Officer, someone stole my cell phone. Do you see that person here?" And the victim says, "No. Can you tell me about the person that did that?" "Yeah, it was a white guy, about medium build. And I see a white guy walking down the street and I arrest this person." Well, what a Wade Gilbert Stovell hearing is going to ask is, "Officer, why'd you pick this person out of the crowd?" Because at any given time, there's probably at least 20 other people that could fit that description. What made you pick this exact person? Other two hearings, Dunaway hearings. What a Dunaway hearing is, it looks at the validity of the arrest. Was it a fair and just arrest? Was it effected in good faith? And also the search incidental to this arrest, was that lawful and reasonable? And then the last one are Sandaval hearings. And what Sandaval hearings is, a judge will make a ruling as to whether a defendant's past criminal record will be allowed in the present trial, whether it is admissible or not. 11, we have the trial. What do trials do? Well, trials adjudicate. They render verdicts, either guilty or not guilty. Really quickly, what happens is there are two sides. There's the prosecution side, which represents either the person wronged, or if the person decides that they don't want to press charges, the prosecutor can decide to continue with the case and prosecute this case on behalf of, at least in New York, PSNY, or the people of the state of New York. And then the person who has been accused of the offense is allowed counsel too. So we have the prosecution or district attorney side, we have the defense side. Both give what's called their opening statements, and then the prosecutor talks, the defense talks, the prosecutor might want to talk again, the defense might want to talk again. Closing arguments are given, and then a jury will get sequestered and render the verdict. If a person is guilty, obviously they're going to either go to jail and or prison, and we'll find this out at the last part, number 12, in the sentencing stage. At the sentencing stage, if I have been found guilty of a felony, I'm going to serve my sentence in a state prison. The minimum sentence I can serve is, if you remember chapter 1 year plus 1 day. Could be life imprisonment. In other jurisdictions, other states, the death penalty might be on the table depending on what the offense is. In New York State, there is no death penalty. It's actually on the books. It has never been repealed, but it has been found to be unconstitutional. If I am convicted of a misdemeanor, at minimum, I'm going to do 16 days, up to a maximum of 1 year. Where am I going to do that sentence? I'm going to do that in a city or county jail. In New York City, that would be Rikers Island. At least as of right now, they're looking to do 5 borough houses. Hasn't fully happened yet. If I am convicted of a violation, at maximum, I can serve 15 days in a city or county jail, or in this case, Rikers Island. More often than not, if a person is, first of all, I've never ever heard of a violation going to trial. They're usually adjudicated right then and there, and usually it's more often than not time served. That's about it for this chapter. For all 3 of my classes, be on the lookout for a quiz. A quiz is definitely going to happen because I've given you a lot of information. And I just want to make sure you've absorbed most of it. The Zoom class will probably happen in about 2 or 3 weeks. I want to get 1 or 2 chapters in first, and then we'll start, I'll start taking your questions. If there are questions, you feel free to email me. And I wish you all a great day, and stay safe, everybody. Have a good day. Bye.